So I will be dealing first with the relevant legislation of the last 40 years, then looking at some of the judgments recently emanating from the court in Luxembourg, and as we go along, considering the influence they have, if any, on the legal position within England. I then consider the legislation which has been enacted or proposed by the Commission and Parliament, and briefly explore whether and to what extent that might make a difference to the way in which consumer protection might develop in Britain. One of the key distinctions in the court's reasoning was between services and products. The services provided by a newspaper and giving advice, and the product of a newspaper being the printed copy. Now, in terms of divergence within the UK, I don't think there are any surprises in the conclusion that was reached by the European Court. And post-Brexit Britain, it is nigh uncertain to have reached the same conclusion insofar as the claimant seeks to shoehorn the Consumer Protection Act claim, the facts of a negligent misstatement case based on a newspaper article, into a Consumer Protection Act claim. Just rattling through the provisions of the contents of that directive, it does make provision broadly for the identification in each member state of qualified representative bodies who can conduct collective redress actions, and it makes provision for flexible procedural features, either opt-in or opt-out, for certification processes, for third-party funding, and for disclosure provisions, none of which should come as a surprise to any English practitioner, but it seeks to broaden the scope of those provisions across the community.